Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this discussion. In today's discussion, we're in session number 2 of our new program entitled Update on Trends in the Cumulative Trauma Injury Claim. And this program is a re-recording of a prior program that we published in 2021 entitled Cumulative Trauma and the QME. And the purpose of this program is to share with you what we've learned about the QME's role in the processing and administration of cumulative trauma injury claims, what we've learned in the time period between the original publication of this program in 2021 and now when this program is being recorded in 2024. And if you think about it, and what you're going to learn as we go throughout our next several sessions together, is that much of cumulative trauma injury claims has to deal with legal and administrative matters. And you may be wondering, what is my role as the Qualified Medical Evaluator in the evaluation of cumulative trauma injury claims? And that's what we want to explore throughout this program. But interestingly, in order to understand your role as a medical evaluator in these sometimes difficult to comprehend claims, it's important that you understand how it is that these cases come to you for your evaluation, how it is that your phone gets ringing for an evaluation of these cases, how it is that these cases come to you. In other words, it's important for you to understand what's operative behind the scenes that bring these cases to you for your medical determinations, whatever they may be. So what I want to share with you, especially in today's program, are some of the legal and administrative matters that are operative behind the scenes that govern these cumulative trauma injury claims and basically determine whether the claims fly, in other words, whether the claim succeeds and gains legs as a valid and accepted claim, or in the alternative, whether or not the claim gets defeated or gets denied and never gets off the ground in the first place. And there's a lot going on behind the scenes that many times is unbeknownst to us as qualified medical evaluators. And that's what we want to unearth and expose and actually exploit in our evaluations so that we can quickly and accurately arrive at the proper conclusions in these cases, get these reports written, get them off our desks quickly and accurately, and then move on to the next evaluation. So that's our objective in this program. And before we get started into today's topics, let's just review where we've come from so far in session 1. In session 1, we talked about some of the distinctions between specific and cumulative trauma injuries, and I predicted and postulated that probably over your next 10 evaluations, at least 6 or 7 of those evaluations are going to include some component of a cumulative trauma injury claim, whether it be a combination of a specific injury combined with a cumulative trauma injury, or solely a singular cumulative trauma injury claim, or even multiple claims for cumulative trauma injury. In other words, as we discussed in session number 1, the filing of cumulative trauma injury claims is on the rise. So you're going to be seeing these cases. So I want to make sure that I have your attention throughout each and every one of these sessions of this program, because you're going to be seeing these cases. And when it comes time for you to render your opinions and conclusions, you need to have clarity of thinking when it comes time for you to provide clarity of opinions within the body of your report. So we talked about the distinctions between specific and cumulative trauma types of injuries. And we gave the definition of cumulative trauma injuries. Cumulative trauma injuries are due to repetitive mentally or physically traumatic activities extending over a period of time. And you can use this definition within the body of your report. If you employ this definition will work for you and will add substance and credibility to your determination when you specifically refer to this definition in the body of your report. So there's a couple of different definitions that I shared with you in session number 1. The first one came from Labor Code section 3208. The second one comes from the California Supreme Court, the highest court in the state. They tell us that a cumulative trauma injury occurs as a result of a number of minor strains over a period of time, unquote. And you might wonder to yourself, what is the period of time? How long or how short is the period of time for which an injury can qualify as a cumulative trauma type of injury? And I'm here to tell you that the period of time can be infinitely long. It can be over the entire career of an injured worker's working career, and it can also be very, very short. And I've seen cumulative trauma injury claims that involve cumulative trauma only over the course of a single day's worth of work. And you can imagine how that could happen. In a single day, a worker could suffer a cumulative injury as a result of repetitive activities over the course of even a single day. The Supreme Court went on to say these traumas are generally minor in and of themselves, but on a cumulative repetitive basis, they eventually result in disability. And we'll talk more about what exactly constitutes disability here in just a little bit. Now, this definition comes from the Court of Appeal. The Court of Appeal is the next higher court after the Workers' Compensation Appeals Board. Okay, so the hierarchy is as follows. The first decision-making level in the courts is the workers' compensation judge. Disputes after that go to the Workers' Compensation Appeals Board. After that, disputes go to the appeals court. And after that, and eventually, if the dispute survives, it ends up at the Supreme Court of California. So this is a quote from the Court of Appeal. Court of Appeal tells us that a cumulative injury is one which results from repetitive events occurring during each day's work, which in combination cause any disability or need for medical treatment. Those are the two criteria that qualify both specific incidences and cumulative activities over time that qualify both of those as injuries. So both specific injuries and cumulative trauma injuries, in order to qualify as injuries, rather than just aches and pains and normal pains of daily living, have to either cause disability and or result in a need for medical treatment. Any condition that does not cause disability and does not cause a need for medical treatment does not rise to the level of injury as injuries defined in California workers' compensation. And then we talked about the distinction between first aid and actual medical treatment. And the distinction is that injuries that require only first aid do not rise to the level of a compensable injury under California workers' compensation law. And this applies to many injury conditions that occur in the workplace. Many injury conditions that occur in the workplace simply respond to first aid treatment and do not require any ongoing medical treatment and do not cause disability. And so they do not rise to the level of an injury as injuries defined in California workers' compensation. Okay, so that was what we went over in session number 1. That brings us to our topics today in session number 2. Okay, so with that as a background about the distinction between specific and cumulative trauma injury claims, what I want to talk to you about today are some very important topics that are going to be relevant for your next 6 to 7 out of 10 requests for evaluations, all dealing with cumulative trauma injury claims. And the first thing that I want to spend quite a bit of time on in today's discussion has to deal with the date of injury for cumulative trauma injury claims and how you as the qualified medical evaluator actually participate in setting the date of injury for these types of claims. And that makes cumulative trauma injury claims distinct and different and unique from specific injury claims. With specific injury claims, we as the qualified medical evaluator don't establish the date of injury. The date of injury is simply the date upon which the incident or injury occurred. That's a question of fact. Well, in cumulative trauma injury claims, the date of injury is not so clear-cut and dried. There's quite a bit of gray area that surrounds the date of injury in cumulative trauma injury claims, and many times it's you as the qualified medical evaluator that actually sets the date of injury. And we're going to talk about the actual importance of the date of injury, which is not so important to us as qualified medical evaluators, but it's important for the administration of the claim, and it's certainly important for the injured worker upon whom the benefits are determined upon the date of injury. So it's important for the injured worker. And I want to share with you, how it is that you as the qualified medical evaluator many times are responsible for establishing the date of injury. But we don't really know this because we're not told this in the cover letters. No one ever tells us that part of the assignment for the evaluation is to determine the date of injury. But behind the scenes, you don't know this, but your opinions are used to establish the date of injury. And I want to share with you exactly how, so that you can be aware of this when you're evaluating the injured worker, and so that you can be aware of the importance of your determinations, whatever they may be, in establishing this important date of injury. And then the second thing I want to share with you today, and we'll just get into an introductory discussion of this, because this is a vast topic, and that is the post-employment cumulative trauma injury claim. And I'll share with you some statistics about the post-employment cumulative trauma injury claim as we go along here this morning. But for now, you need to learn to evaluate these types of claims. And evaluating these types of claims begins first with being able to recognize when you're dealing with a post-employment cumulative trauma injury claim. Now, what a post-employment cumulative trauma injury claim is a claim that's filed where the injured worker is alleging a cumulative trauma injury, and the claim is filed after the employee and the employer have separated their relationship. Sometimes these are referred to as post-termination cumulative trauma injury claims, but actually the proper term is post-employment cumulative trauma injury claims. And the distinction between the phrase or the term post-termination and the phrase post-employment is that the phrase post-termination implies that the separation of employee from employer was initiated by the employer. Okay, so post-termination would typically indicate that the worker was fired, was terminated, was laid off, was given a mandatory sabbatical, something like that. Post-termination implies that the separation was initiated by the employer, whereas the term post-employment is a more neutral term that's independent of who initiated the separation. It's a more neutral term. That's the politically correct and currently used term, post-employment. But sometimes you'll see the phrase post-termination, and you'll see defense attorney cover letters that suggest that the defense attorney is employing what's referred to as a post-termination defense. And I'll share with you the post-termination defense. But we're going to refer to these claims as post-employment cumulative trauma injury claims. And you're going to get a throng of these cases, especially if you're a medical evaluator in Los Angeles or San Diego counties, which are the centers of the universe of the post-employment cumulative trauma injury claims. These claims are rampant down in the Los Angeles and San Diego counties. So if you're a medical evaluator, certainly in those counties, you need to be able to recognize and you need to be able to handle these cases quickly and accurately. And even if you're not in Los Angeles County or San Diego County, you still need to be able to handle these cases because you're going to see a load of these types of cases over the course of your career as a qualified medical evaluator. So with that as our introduction to today's discussion, let's continue on in our new series entitled Update on Trends in the Cumulative Trauma Injury Claim. Okay, so let's just remind ourselves of some statistics regarding cumulative trauma injury claims. And as we talked about in our last discussion, these statistics are from the Workers' Compensation Institute Review Board for 2018 and 2022 reports. So the first one is that the proportion of claims involving allegations of cumulative trauma have increased sharply. And we're experiencing this as qualified medical evaluators. This is why our phones are ringing off the hooks for for requests for more evaluations these days. Now, interestingly, and we're going to discuss this more today, cumulative trauma injury claims have a long delay between the injury occurrence and the time of filing of the claim. And this is specifically appropriate to the post-employment cumulative trauma injury claim, where the claim is filed days, weeks, months, years, and even decades after the termination of the employment relationship. So this is what accounts for the long delay. These claims have a long delay between the injury occurrence and the time of the filing of the claim. Okay, these claims can be filed as many as decades after the injury has occurred. Cumulative trauma can have exposure over years and decades, but the liability for CT claims is spread only over the last year of injurious exposure. This is what brings us into the equation. Many times the exposure period can be covered by multiple employers. Multiple employers are involved over 5 years, 10 years, whatever the period of injurious exposure. And these cases come to us for our determination as to what's going on and what is the date of injury. And that is what results in one or more of the other insurers being responsible for liability for the claim. Cumulative trauma injury claims are likely to involve multiple body parts, including every single part of the body, including internal medicine parts, including psychologic injury parts and orthopedic injury parts. And these cases can become quite complex quite quickly, and therefore you need to understand exactly how to handle these cases so that you can quickly and accurately resolve these cases. Cumulative trauma injury claims are more likely to involve representation by an applicant attorney, and many times it's the applicant attorney themselves that file the claim for cumulative trauma and are the party responsible for bringing the issue of cumulative trauma into the injury claim. So these are some statistics on cumulative trauma injury claims. I think we may have one more. Let's see. Yes, and finally, and this makes great sense, cumulative trauma injury claims are more likely than specific injury claims to include frictional costs, such as liens and medical legal costs, like the cost for our evaluations. And many times these cases involve or require many touches, many inputs from us as qualified medical evaluators, many reports, many supplemental reports, many reevaluations, many depositions, all of which carry with them costs. These are referred to as frictional costs. So cumulative trauma injury claims are expensive claims on the systems because they include these other costs that are not as typically associated with specific injury claims. So cumulative trauma and the handling of cumulative trauma injury claims is a big deal in our profession, and the purpose of this program is to help you more accurately handle and resolve these claims. Okay, so let's talk now about important concepts related to the date of injury for cumulative trauma injury claims. Now, for specific injury claims, the date of injury is fairly straightforward. For specific injury claims, the date of injury is described under Labor Code 5411. 5411 tells us that the date of injury, talking about specific injuries now, except in cases of occupational disease or cumulative injury, which have their own labor code that determines the date of injury. That's our next labor code, Labor Code 5412. But for specific injury claims, the date of injury is that date during the employment on which occurred the alleged incident or exposure for the consequences of which compensation is claimed. So for specific injury claims, the date of injury is rarely disputed, is fairly cut and dry without any gray areas. And specific injuries have a statute of limitations. The statute of limitation is 30 days for the reporting of the injury, 30 days for the reporting of injury. Injuries that are reported beyond 30 days can be denied based on statute of limitation defenses. And then once the injury is reported, and if it's reported within 30 days, there is a 1-year statute of limitations for filing the claim for injury. In other words, not all injuries get filed as claims. Okay, many injuries simply get better and do not go on to become living, breathing creatures, living, breathing claims under workers' compensation. So those are the two statutes of limitation that also will apply to cumulative trauma injury claims, but cumulative trauma injury claims do have a couple of exceptions, but in general, the statute of limitation for reporting the injury is within 30 days of the occurrence of the injury, and then once the injury is reported, there's a 1-year statute of limitation for the filing of the claim for the injury. So if there's a 30-day statute of limitation for reporting of the injury, you might ask yourself, what constitutes proper reporting of the injury? And I'm sure you're aware of this dispute that can arise between employee and employer. And many times you'll sit with an injured worker and the injured worker will tell you that they reported the injury. And yet at the same time, the employer is disputing that the employee ever even reported an injury. And both parties are engaged in this dispute over whether or not the injured worker actually reported the injury. And this is an area of great dispute. So let's talk about what the law has to say about what constitutes proper reporting of the injury. So proper reporting of the injury is described in two labor code sections, sections 5400 and 5402. So let's go over those. So here's 5400. And 5400 tells us that with a couple of exceptions, it says, except as provided by sections 5402 and 5403, those are the exceptions to this general rule under 5400. It says here, no claim to recover compensation under this division shall be maintained. In other words, no compensation shall be paid unless within 30 days, and here's your statute of limitation, it's described in law in section 5400. It says, unless within 30 days after the occurrence of the injury, which is claimed to have caused the disability or death, there is served upon the employer notice in writing, signed by the person injured or someone in his or her behalf. So this is quite a strict reporting requirement. It requires that the injured worker provide written notice, signed written notice, and that signed written notice must be provided within 30 days of the date of the injury. So that's a fairly strict and tight requirement. And many injured workers do not meet this strict and tight requirement. And sometimes you'll ask an injured worker, well, did you report the injury? And the injured worker will say something like, well, I had my son call the supervisor on the phone, right? And that having the son call the supervisor does not quite rise to the level of the strict requirement that's described here under Labor Code section 5400, which requires written notice, signed written notice within 30 days. And this is something that few injured workers comply with. But there are some exceptions to this tight reporting requirement. And here in 5400, it tells us where those exceptions are to be found. They're to be found in 5402 and 5403. So for the purposes of this program, let's go over what 5402 has to say about lessening and loosening the strict reporting requirement required under 5400. Okay, so Labor Code section 5400 sets up this strict and tight requirement for reporting, which if it was the only labor code that governed the reporting of industrial injuries, many claims could be denied and defeated because injured workers simply failed to comply with this tight and strict reporting requirement. But it's Labor Code section 5402 that greatly liberalizes what actually constitutes a reporting of the injury. We're going to go over this in all of its sections and in some great detail. So 5402 tells us that knowledge of an injury obtained from any source right? Remember the injured worker that said, I had my son call the supervisor? The son constitutes any source. A Post-it note constitutes any source. A voicemail message recording, a text message, an email, all constitute and qualify as any source under this Labor Code section. It says knowledge of an injury obtained from any source on the part of an employer by his or her managing agent, superintendent, foreman, or other person in authority. You see how liberal this is? In other words, you don't have to simply report this to the boss. You can report this to the shift supervisor, the shift foreman, or any other person in authority. And you can imagine that there is great dispute over who qualifies as a person in authority, right? Does someone in human resources constitute a person in authority? Does the night security guard constitute a person in authority? You can imagine that this comes into dispute all the time. And then it says, or knowledge of the assertion of a claim of injury sufficient to afford the opportunity to the employer to make an investigation into the facts is equivalent to service under Section 5400. Isn't that fascinating? So Section 5400 goes to great lengths to set up this strict and tight reporting requirement of a signed written statement within 30 days and these tight parameters. And then 5402 comes along and greatly liberalizes the requirements of 5400 and says basically you don't need any of those things under Labor Code Section 5400 because knowledge of an injury from any source, right? I left a Post-it note on my supervisor's computer monitor. I left a voicemail. I told the night manager. Okay, so this Section A greatly liberalizes the formally strict and tight reporting requirement described under 5400. Now, this is where these cases come to us, okay? Pay close attention to these next two sections of 5402. It says that if liability for the injury is not rejected within 90 days after the date the claim form is filed, the injury shall be presumed compensable under this division. So what that means is that the employer has 90 days to investigate the claim to decide whether to accept or to reject the claim. And if the employer does not act within 90 days, then the injury is presumed compensable. It automatically, by default and by law, becomes compensable if the claims administrator blows the 90-day timeline under which the claims administrator can investigate the claim. Then it goes on to say this presumption, the presumption of the compensability of the claim, the presumption of this subdivision is rebuttable only by evidence discovered subsequent to the 90-day time period. So if the claims administrator blows the timeline and the claim becomes accepted after 90 days, the acceptance, the presumed compensability of the claim can only be rebutted by evidence that is discovered after the 90-day time period. It cannot be rebutted by evidence that was available prior to the 90-day time period, because if the evidence was available prior to the 90-day time period, why didn't the claims administrator act on that evidence within the 90-day time period? So this is sort of the act now or forever hold your peace type of clause here in Section B. Okay? So interestingly, the claims administrator has 90 days to decide whether to accept or reject the claim. And you might think, well, that could hang out an injured worker for quite a bit of time. If we have an injured worker who needs medical treatment and they have to wait 90 days for a determination, that doesn't quite seem right. Well, here is the protection clause for the injured worker. It says that no matter what the claims administrator decides to do during the 90-day time period, it says within 1 working day after an employee files a claim form, the employer shall authorize the provision of all treatment for all injury conditions that are declared on the claim form. It says the employer shall authorize the provision of all treatment for the alleged injury and shall continue to provide the treatment until the date that liability for the claim is accepted or rejected. Until the claim is accepted or rejected, liability for medical treatment shall be limited to $10,000. So this is going to explain to you, you're going to have an aha moment here in just a minute. This just explains why we get so many of these cases. The reason we get so many of these cases is because the claims administrator, in attempting to stop the bleeding from the $10,000, immediately gets out the denied clamp and decides to reject the claim. Because until the claims administrator either accepts or rejects the claim, and they have 90 days to do so, but while they're deciding, they need to continue to provide medical treatment to the injured worker. And medical treatment is up to $10,000 for each injury claimed on the claim form. So you can imagine an injured worker who has claiming 5 injuries in either a specific or a cumulative trauma injury, and the liability can quickly escalate. Well, in order to stop the bleeding from the separate pot of funds under 5402C, this is a separate pot of funds aside from the claim itself. In order to stop the bleeding from this fund of monies, the claims administrator has to deny the claim. So these are claims that get denied, and these cases come to us as denied cases for our determination. And this is the reason why the case becomes a denied case, because the claims administrator is attempting to control costs and stop the bleeding from this requirement that they provide medical treatment under 5402. So we get these cases, and this is what's operative behind the scenes that bring these cases to us for our evaluations. Finally, this section tells us that treatment provided under subdivision C, this subdivision right here that we just went over, shall not give rise to a presumption of liability on the part of the employer. So just because the employer, in some cases, willingly provides this medical treatment up to $10,000, that provision of the medical treatment does not automatically give rise to a presumption of liability for the claim. Many times the claims administrators will authorize this 1 or 2 or 3 visits of treatment under this section in order to get a sense of the condition and the complaints of the injured worker. So these are sometimes valuable and valid medical appointments under this section of 5402. Okay? So that explains why your phone begins to ring for these types of cases, because these cases have become rejected by the claims administrator. Okay, so let's talk about now the date of injury for cumulative trauma injury claims. So specific injury claims are described under Labor Code 5411. Cumulative trauma injury claims are described under the very next section of the law, which is 5412. So 5412 tells us that the date of injury for a cumulative trauma injury claim has a different set of criteria than the date of injury for specific injury claims. For cumulative trauma injury claims, the date of injury is that date upon which the employee first suffered disability. That's criteria number 1. The date that the employee first suffered disability and, okay, it says and, it doesn't say or. So in other words, both of these criteria have to coexist. It says and either knew or in the exercise of reasonable diligence should have known that such disability was caused by his or her present or prior, notice here it says prior, prior employment. So this phraseology opens up the claim, the universe of possible claims against former employers. It says prior employment. Okay, so an injured worker can be at a new job for days, weeks, months, and years and can file a claim against the prior employer, and that's allowed under this section of the law, which establishes the date of injury. So let's dissect this with a fine-tooth comb, because this is operative in many of the cases that you evaluated, that you will evaluate, and there are cases upon cases upon cases that deal with disputes over the date of injury. The date of injury for these types of cases is critical, as we'll discuss in just a couple minutes. So it says 2 things have to coincide. Number one, the employee must first suffer disability, and disability is going to be defined as compensable disability. Compensable disability is either total temporary disability, okay, time off work that's compensable, or compensable permanent disability, okay? Modified work duties do not constitute compensable disability. So here, where the Labor Code refers to disability, they're referring to compensable disability, either in the form of TTD or in the case of PD, permanent disability. Now, think about this for a minute. In the case of the post-employment cumulative trauma injury claim, there's no evidence usually that the employee has ever suffered disability. They've never suffered any TTD. They worked right up until their last day of employment. When the employment relationship ended, either by way of termination or layoff, they continued working. There's no evidence of at least TD. Well, at that point, establishing a date of injury hinges and depends on the establishment of permanent disability. And this is where these cases come to us for our determination. And it's the determination from us that the examinee has suffered a permanent disability that helps establish the date of injury, because the date of the permanent disability becomes the first date that the employee suffered any disability as a result of the injury. Isn't that interesting? And I'll share with you a case known as the Rodarty case that exactly illustrates this exact occurrence. So that's the first criteria. The employee must first suffer disability, okay? And then the second thing is that the employee must have the knowledge that the disability was caused by their present or prior employment. Now you can imagine that this knowledge requirement here, the requirement that the employee have knowledge, is a point of great dispute among the parties. And you can read into that sort of by reading the language of the law. It says that the employee either knew or in the exercise of reasonable diligence should have known. So you can imagine circumstances in which the employer says, oh, come on, you should have known. The employee says, no, I didn't know. I had all these problems, but I'm just a lay person. I'm not a medical person. I didn't know. And the employer comes back and says, oh, come on, you're not a dummy. You're not an idiot. Any person with reasonable diligence should have known. And you can imagine that there's great dispute that goes back and forth between the parties over these issues. So we'll explore these issues and talk about how the courts have resolved disability and how the courts resolve knowledge and what actually constitutes disability and what constitutes knowledge. But for the purposes of understanding the date of injury, you can see that the dates that the employee first suffered disability and the date that the employee had knowledge that the disability was due to the workplace duties can come days, weeks, and months, and years, and decades after the last date of working for the employer. So imagine a fire captain. Fire captain works for 30 years fighting fires, finally retires, and then 3 years after retirement develops a cough. The first sign of any disability is 3 years following the last date of employment. And the fire captain goes to his primary care physician. Primary care physician does an evaluation and diagnoses the fire captain with some sort of a pulmonary disorder. Let's call it, chronic bronchitis or lung cancer, heaven forbid, or what have you. And the primary care physician says that this condition is due to your work or was contributed to by your work. And the fire captain, light bulb goes off, and the fire captain at that point gains the knowledge that the cough is related to the employment. He gains the knowledge through a medical determination by the primary care physician. So you can see that the fire captain gained the knowledge and suffered the disability at some point far, far removed from the last day of employment. And this is a legitimate circumstance. In this case, this is an occupational disease suffered by the fire captain. Well, same scenario applies to cumulative trauma injury claims, where the employee can not have any disability whatsoever, and therefore, in the absence of any disability, there's certainly no knowledge, but can have no disability and no knowledge. But later on, the disability manifests itself and the knowledge manifests itself, and now we have the concurrence and intersection of these two factors that establish the date of injury. And many times, for our purposes, many times, this intersection occurs at the qualified medical evaluation with you. Okay, so we have these two factors. We have the disability and we have the knowledge that the disability was either caused or contributed to by the prior employment. Okay, so let's take a look at this sort of diagrammatically. Here we have a diagram that shows the intersection of knowledge and disability, which defines the date of injury under 5412. So it's this disability here. This is what typically brings a person into their doctor, whether it be the primary care physician or primary treating physician. They're suffering some sort of a disability, whether that be a neuromusculoskeletal issue, an internal medicine issue, or an occupational disease of some sort. Okay, so imagine a skin cancer case. A person goes to their primary care physician with a lesion on their skin. They're suffering some sort of disability. And the primary care physician says, well, this skin cancer is due to your job as being a lifeguard. And it's at this point in time that the worker or person, depending on what you want to call them at this stage, let's call them a worker, the worker develops the knowledge that this condition on their skin is due to the employment situation and the employment circumstances. It's due to their job duties. So it's at this point in time where these things intersect. Now see, there was no intersection until the injured worker gained the knowledge from the primary care physician. All the while, the injured worker had a lesion on the skin, but had no knowledge that the lesion on the skin was due to the work injury. So the disability was present. Okay, the disability was present. But it's not until they gain the knowledge, usually through medical advice, that the disability and the knowledge intersect. And on that date where these two components intersect or collide, that's what establishes the date of injury under Labor Code 5412. Now, the date of injury is a critical date, and there will be many, many arguments over the actual date of injury. The date of injury, whatever it may be, it's referred to as the 5412 date of injury, is what does several things. This date does several things. Number one, it sets the statute of limitations under Labor Code 5405, the statute for filing the claim, that is. It establishes the rate of indemnity benefits, okay, depending upon which benefit schedule was in effect on the date of injury. It determines the dependency status. It determines the timelines for petitions to reopen under 5410 and 5804. And the date of injury, as you know, some of these claims can be reopened within 5 years of the date of injury. And so therefore, the date of injury is a critical determination over which great dispute can arise. And another thing is the date of injury also establishes the date for the post-termination defense. Remember, we've talked about this in session number 1, that Labor Code Section 3600, Section 10, one of the affirmative defenses, generally bars, blocks, bans, prevents, prohibits claims that are filed post-termination or post-employment. The law, 3610, blocks these types of cases. But there are a couple of exceptions where claims that are filed post-employment, like the fire captain's claim, there are a couple of exceptions where these claims can survive. And establishing the date of injury is critical. If the date of injury is established before the date of termination or layoff, or notice of termination or layoff, then the post-termination defense does not apply. But if the date of injury is established after notice of termination or layoff, then the claim can arguably be denied by the post-termination defense unless the applicant can prove by a preponderance of the evidence that one or more of 4 exceptions to the post-termination defense are applicable, okay? So another relevance of the date of injury for cumulative trauma injury claims. Now, the statute of limitations under Labor Code Section 5405, which we just talked about in our last slide, is a 1-year statute of limitations. So the time frame is narrow. It's not infinite. It's not infinite. The statute of limitation of filing a cumulative trauma injury claim is a 1-year statute of limitation. But in a burst of liberal construction in favor of the injured worker, the clock does not begin to run until the date of injury can be established, or the date of injury is established. And again, the clock does not begin to run until the injured worker first suffers disability and has the knowledge that their disability has work-relatedness. In other words, that there's industrial causation for the disability. So can you see many claims, how many claims are denied by the claims administrator based on a statute of limitations defense, where the claim has not been filed for greater than 1 year, but in argument, the applicant, the injured worker, claims no knowledge. They say, I didn't know. I didn't know that this back pain was due to my work. I didn't know that this lesion on my face was due to my work. I didn't know. And this is where the employer is going to come back and say, come on, within reasonable diligence, you should have known. You should have known. And there's this great dispute back and forth over the knowledge. And we'll talk more about what actually constitutes knowledge here in our next session. But this is important, and this is why these cases come to us under these statute of limitation denials. They come to us for our medical determination on the examinee's actual condition, and sometimes our medical determination actually establishes this date that begins the statute of limitations time period. Okay, very, very interesting. So you can see that with all of these forces and all of these factors operative, these cumulative trauma injury claims, unlike specific injury claims, can go on and on and on forever. And the claims generally are filed at great times removed from the last period of injurious exposure. So let's explore that idea a little bit more. So here we have a graph, and this is from the Workers' Compensation Institute Review Board, and it shows that unlike specific injury claims, cumulative trauma injury claims are reported days, weeks, and months, years, and even decades following the date of injury. And the statistic from the Workers' Compensation Review Board from this study, The World of Cumulative Trauma Injury Claims, which I've included in your reference materials for this program, this study tells us that it takes greater than 7 years from the date of injury for almost all of the CT claims to be reported. So here is California CT claims. This is the time period required for 98% of all claims to be reported. Why does it take so long? Well, the reason is for the reasons that we just talked about, because the dates and the timelines are greatly extended. An injured worker cannot perhaps suffer disability until 2 years after the last date of employment, maybe 4 years after the last date of employment, maybe 6 years after the last date of employment. There are cases where the employee has not suffered disability and gained the knowledge that that disability was due to the workplace duties for 7 years after the last date of employment. So with cumulative trauma injury claims, the timelines can be greatly extended. All the while, these claims are incurring frictional costs along the way. So compare that to the specific injury claims. This is all claims, including indemnity and medical. This is California indemnity claims only. And you can see that this timeline is less than 3 years here. for 98% of all specific injury claims to be reported. So the cumulative trauma injury claims is nearly 3 times as long as the specific injury claims. And California is even more liberal than other states. Median states' all indemnity claims have a much, much shorter time frame for reporting these claims. So you can see that these cumulative trauma injury claims are quite a burden on the system in terms of the time out into the future that these claims survive and continue on in their life cycle, and the number of costs that are associated with these claims over great time periods can become quite a burden on the system. And so here we have another graph from the Workers' Compensation Institute Review Board, and it shows the gap between the initial cumulative trauma injury claims that are filed for a given year and the ultimate number of claims that are attributed to that year, as later reported claims filed get to be assigned to a particular year. So for example, this graph here shows the rise in cumulative trauma injury claims over time between the time period 2008 and 2016, when the last major statistics were available. It shows the rise in the number of claims that are filed in each of these years. Now, in addition to those claims, we have here the ultimate, it says here the ultimate number of claims that are attributed to each particular year. So for 2008, we had this number of claims being filed in 2008 for cumulative trauma injury claims. But then again in 2008 here, we have cases being filed in 2008 that had the injury suffered earlier here in 2006, 2005, 2004, but that claim was not filed until 2008. So here is the graph for claims that were filed in 2008. Here is the cases that were filed in 2008 but are attributed to an earlier date of injury. And you can see that there's a gap in the number of those cases. Okay? This line represents the cases that are filed for date of injury in 2008. This graph represents the number of cases that were filed that are attributed to 2008, but for which have an earlier date of injury, but not filed until 2008. There's a gap between those types of cases because of the delay in the reporting and the delay in filing of cumulative trauma injury claims. Well, you notice as we get out here in 2014, 2015, and 2016, the gap between these two lines, the gap between CT claim proportions at earlier periods and later periods has widened. It's widening with more cases being reported later. Okay, this widening of the gap is because more and more cumulative trauma injury claims are being reported later. And our last graph told us that the statistic was it can take as many as almost 8 years for all of these claims to finally and eventually be reported. So very, very interesting. So this tells us as qualified medical evaluators, we have a flood of evaluations coming for cases that are just now being reported that are alleging cumulative trauma injury for earlier time periods. So doctors, isn't that interesting? With all of these variables, are you starting to see why, and are you starting to understand why so many of the cases that you're evaluating are dealing with allegations of cumulative trauma injury claims? It's because of all of these disputes that can arise along the life cycle of a cumulative trauma injury claim, not the least of which are disputes over the date at which the employee first suffered disability, which many times for post-employment cumulative trauma injury claims is never during the employment period, right? The injured worker worked all the way up to the last day of employment when they were laid off for COVID, for example, or laid off due to company downsizing, or were terminated due to lack of being able to meet production quotas or whatever. There was no evidence of any disability at all during the period of employment, and the injured worker comes to us for a qualified medical evaluation. never having suffered any compensable disability. Well, it's our evaluation that can establish the compensable disability. So your evaluation could be the evaluation that declares the examinee permanent and stationary, for which the examinee qualifies for a permanent impairment rating, for which they will receive a disability rating or a disability award. And it's our evaluation that establishes or contributes to the date of injury in these cumulative trauma injury claims. Isn't that fascinating? This is what's happening behind the scenes, many times unbeknownst to us. But if we understand what is happening behind the scenes, it helps clarify our role in these types of cases. So again, both specific injury claims and cumulative trauma injury claims both have a 30-day statute of limitations for the reporting of the injury, 30-day statute for the reporting of the injury, and a 1-year statute of limitation for the filing of the injury. And both of these are areas of great dispute, and those great disputes are what bring these cases to us for our medical determinations. Now, we don't render opinions on statutes of limitation issues, but it's important for us to understand what's going on behind the scenes that bring these cases to us for our medical determinations in these cases. And we'll talk about what exactly is the QME's obligation, medically speaking, in these cases in our very next session. And then in our next session, we're going to delve deeper into the post-employment cumulative trauma injury claim, because you're going to see so many cases that involve an allegation of cumulative trauma injury when that allegation is filed post-employment, meaning after separation of employee from employer. And these types of cases have an exact handling. And the handling of these cases first begins by recognizing what it is that you're dealing with. If you can recognize that you're dealing with a post-employment cumulative trauma injury claim, then you can set about the process of resolving that claim accurately and quickly. And that will be the topic of our next session. So doctors, I want to thank you for taking the time to join me on this session. I know some of these topics and concepts are sometimes difficult for qualified medical evaluators to get their heads wrapped around, but it's important that you understand some basic principles, which are the principles that causes your phone to ring for these evaluations. So I want to thank you for joining me on today's session. I look forward to being with you on our next session of our new program entitled Update on Trends and Cumulative Trauma Injury Claims. For now, this is Dr. Perry Carpenter. I'm wishing you best success in your career as a qualified medical evaluator.